Preparing for the inevitable. The importance of planning. The oft-quoted expression about death and taxes is somewhat overused, but perhaps that is because it expresses such a basic truth. The mortality rate for humans is 100%. Another truth is that a great number of people never face the reality of that insight. The result of such unwillingness to address the inevitable often means significant difficulties for those left behind. In the U.S., one of two entities decides the distribution of assets and how your loved ones fare in the process. Without a will or proper documentation, the government appoints a stranger to follow specific laws to finalize your estate. Any specific obligations, concerns, or priorities you leave behind is irrelevant to the impersonal process prescribed and followed. The second method is that your wishes and decisions, as set forth in properly prepared legal documents, dictate distribution to the estate. Aside from following personal priorities, a process of planning prevents erosion of the estate from taxes and other expenses. It is actually quite ironic that many people are so diligent in their life's work, accumulate substantial assets, and then fail to exercise proper diligence over this vital process. The basics of preparation. The nature of and complexity of the laws governing estates virtually mandate involvement of an estate attorney. The relevant laws, particularly pertaining to taxation, change quite frequently. A major time commitment of estate attorneys is the tracking of these changes and ensuring their clients' documents reflect them. A professional financial planner or wealth manager is often involved as well. Even moderate estates benefit from the advice of these professionals working in concert. The size of a person's prospective estate determines whether a will is adequate or if preparation of a trust provides better protection. If the estate is handled through execution of a will, the following documents are the minimum your attorney will prepare. Some states and personal situations will require other documents. The basics are the last will and testament. This document details a plan of distribution for the assets of the estate. It also addresses any specific situations such as care of minor children, special bequests, and any specific wishes such as burial instructions. A living will. Medical personnel refer to this document generically as a do not resuscitate document. It provides guidance for end-of-life medical treatment. An advance medical directive. This document defines who has authority to make medical decisions should incapacitation occur. A financial power of attorney assigns and delegates authority to an individual chosen to make financial decisions, including moving assets to any trusts. This power is often invoked in the event of incapacitation. In the event the estate uses trust-based planning, a pour-over will replaces the last will and testament. It facilitates transfer of assets into the final document, the estate trust. In most cases, this will be a revocable living trust. The larger the estate, the more trust-related documents required. An estate planning attorney provides clients with checklists for the numerous items necessary for preparation of these documents. There are also many questions asked to aid in preparation of the documents. As a minimum, these items will include lists of all assets and liabilities, including insurance, all family members and contact information, relevant contracts, titles and ownership documentation, relevant papers, documents and agreements, previous 3 years of taxes, location of relevant passwords, account authorizations, and keys. A qualified estate planning attorney makes the planning process efficient and effective. Taking the step to create an estate plan is one of the best steps to take to protect loved ones.